occurred without advance written notice and was not the result of the administrative disciplinary process under the first paragraph of Section 129. The DOC argues that no administrative process was needed because 2 years earlier I had pled guilty to escape from a forestry camp under Section 83C of Chapter 127. They argue that the forfeiture provision of Section 83B was mandatory and automatic to the criminal conviction under 83C. They refer to this as an operation of law forfeiture and claim that it is required by statute.
Mr. Pierce, as I understand it, you're obviously not incarcerated,
Right.
and are you aware of the principle that says once an issue won't make any difference to the parties because something else has happened, typically when somebody's been released, that we don't consider the issue any longer? It's called mootness.
Yes, I haven't received a brief, but I've heard of that concept.
Okay. Could you tell me what difference it would make to you as you are now released, right? And you've served your entire sentence, correct?
Right. Well, the difference is I claim that I was illegally confined, and in U.S. District Court, I am arguing that I'm entitled to compensation as a result of that illegal confinement.
And have you made a claim for compensation?
Yes, I have.
Okay. Thank you. I didn't mean to interrupt you, but you can continue with your argument.
Okay. In fact, there is only one operation of law forfeiture in the general laws, and that is found in Section 49 of Chapter 127. That forfeiture is directly tied to the criminal conviction in language that is clear and concise, and Section 49's forfeiture does not violate the due process protections granted by the U.S. Supreme Court in Wolf v. McDonald. There is no such language in 83B that links this forfeiture to the conviction of 83C, and I respectfully submit that 83B is unconstitutionally vague in its current state because it does not state what triggers the forfeiture. In justifying this forfeiture, the DOC relies upon Gardner v. Commissioner, a case that was decided after Wolf was decided. What the DOC fails to recognize is that Gardner escaped in 1969, well before Wolf was decided, and as a matter of law, Gardner was only entitled to the legal processes available on the day he escaped and not to ones granted under the later Wolf decision. This fact was not lost on the Gardner dissenters, who referred to the disciplinary process of the first paragraph of Section 129, which I was denied, as providing the due process protections guaranteed by the U.S. Supreme Court in Wolf. It should also be noted that the CMR that governs forfeitures, 103 CMR 410 at Section 14, does not allow an operation of law forfeiture under 83B. And I respectfully submit that the DOC does not have the discretion to forfeit good time under statutes that are not specifically listed in the CMR. In July of 2006, I filed Pierce v. Dennehy, and I argued that Section 83B was unconstitutionally vague. I also argued that even if it wasn't unconstitutionally vague, it still violated the due process protections guaranteed by Wolf. And finally, I noted that a forfeiture under 83B is not specifically provided for in 103 CMR 410-14. Excuse me. Later, I realized that if I was wrong regarding the constitutionality and operation of 83B, I was still entitled to relief for different reasons. I then filed a 30B motion in Orange District Court seeking to vacate the 90-day sentence and withdraw my guilty plea to the escape. I adopted the DOC's argument as my own, and I argued that since the automatic forfeiture was required by statute, I was therefore entitled to be informed of the mandatory forfeiture before the court accepted my guilty plea. The judge denied my motion, and I think he interpreted 83B correctly. Judge Ross ruled as follows. The loss of good time is a statutory punishment that is not dependent upon a criminal conviction for escape. The statute makes the loss of good time mandatory without reference to related criminal proceedings. In other words, the defendant's loss of good time was unrelated to his guilty plea in this court. After Judge Ross denied my 30B motion, I filed my single justice petition. I wrote a letter to the clerk for the SJC and explained that while the petition was seeking relief primarily from the decision in Orange District Court, the same issue was being litigated in Suffolk Superior Court in Pierce v. Dennehy. Therefore, I was unsure as to whether the petition should be presented to the single justice for Hampshire County or the single justice for Suffolk County, and I asked the clerk to docket the petition before the proper single justice. I asked the single justice to make a ruling as to the constitutionality of 83B as to its vagueness. And then if it was constitutional, I asked the single justice to make a ruling as to what triggers its operation. I also asked the single justice to remove Pierce from Suffolk Superior Court because there were no factual disputes. In a world where the definition of the word is open to debate, I suppose it is entirely legal to have one Commonwealth attorney argue in one Commonwealth courtroom that I should be denied my freedom because Section 83B forfeiture was mandatory to a conviction under 83C, while in a different Commonwealth courtroom, a different Commonwealth attorney successfully argues that I should be denied my freedom because 83B forfeiture does not operate upon a conviction under 83C.
Mr. Pierce, forgive me for interrupting you, but I want to just return to the question of mootness. As I understand it, and maybe my understanding is incorrect, the action in the Superior Court was an action for habeas corpus.
Right.
That is a request to a judge that you be released from prison because you have served your sentence.
Right, and at the time I filed it, it was not ripe, so the judge converted it into an action seeking declaratory relief. So there was never an habeas appropriate timeline to decide this issue.
Okay. You told me earlier that you had filed a claim for compensation.
In U.S. District Court, correct?
In United States District Court.
Right.
It might well be that you can prevail on that claim in United States District Court, but the only I think it is correct that the only case we have here is not for compensation, but to get you released from incarceration.
Right, but at the time that I asked that Pierce be removed, it was still then an action seeking declaratory relief, and it only became an habeas action while we were waiting.
Sure. But if you have claims for how good time is calculated and so on, those claims can be raised, provided that there's an appropriate basis in a federal court, in the United States District Court.
Well, Judge Sarris decided Heck versus Humphrey and required me to show cause as to why it should not be dismissed. And I should note that I also filed a petition for habeas corpus before Judge Sarris in September, and I don't know why, but she's carefully screening it, and she's ordered the case to be
consolidated?
Well,
joined?
No,
it's fine. We can check the docket.
She's ordered Magistrate Judge Sorkin to begin a pretrial.
Okay.
Some kind of a pretrial process, so I don't know what the significance of that is, but she surely should have dismissed it as to a lack of, well, first of all, for mootness, but also because it hasn't gone through the entire state appellate process. So I am curious as to why she hasn't dismissed it. I think that given the fact that I'm unrepresented and that I faltered procedurally both in Superior Court and in Orange District Court, I think obviously she has to dismiss the petition, but I think she's going to render a decision that will be helpful in the action seeking damages. However, I would argue...
Let me just interrupt you again to say the following, because your time is almost up.
Yeah.
I want to assure you that we will read all of your submissions, and the fact that you didn't get to make your entire argument here doesn't mean to say that we don't consider your arguments.
And I'd like to remind you that one of the actions that I sought in the single justice petition was to remove Pierce v. Dennehy from Suffolk Superior Court to the full court, so you could decide the constitutionality and meaning of 83B, and then refer it back to either Orange District Court or the Suffolk Superior Court with those questions answered, and then we could have gone on from there. So I would argue in that sense it is not moot, because I am appealing from the single justice's failure to remove.
Sure.
And I argue I was entitled to those constitutional interpretations.
Thank you, Mr. Pierce.
Okay. Thank you.
Ms. Badway?
Good morning. Eva Badway, Assistant Attorney General for the Parole Board. With me at council table is Attorney David Slade for the Massachusetts Department of Corrections.
Did you file a brief?
I did, Your Honor.
Okay.
Because the plaintiff is no longer in custody, he was released from the Department of Corrections on November 14th, 2007. There is no reason to challenge the loss of good time credit. And this
Ms.
appeal
Badway, let me ask you this. I haven't looked at the complaint in the Superior Court. Was it, was action taken in the Superior Court to convert it to a declaratory judgment action?
What happened, Your Honor, is in the Superior Court, initially, Mr. Pierce only sued the Department of Corrections.
Right.
And then he amended his complaint and brought in the parole board and said that the parole was wrongfully
Denied?
revoked.
Revoked.
Correct. But Judge Broussard denied that civil action. But I just want to point out to the court that this started out as an appeal of the denial of a single justice action.
No, I understand that,
Okay.
but I'm trying to find out exactly what.
It
What?
started out as a habeas petition. When it initially started out as a habeas petition
In the
against the
Superior
Department of
Court.
Correction. Correct. But then Mr. Pierce moved to amend his complaint to add the Massachusetts Parole Board.
Okay.
Did he add a count for declaratory relief, or did the judge treat it as a declaratory judgment
I
action?
think that the judge treated it that way, Your Honor. What he tried to say was that
Why did it make it into the single justice session? What was the basis?
Mr. Pierce
Yeah,
filed.
but what's the basis for it?
He wanted both the case, the denial of the motion for a new trial in Orange Division of the District Court, and the Superior Court habeas action to be removed from both of those courts and brought to this court.
Is it clear, leaving aside the Orange District Court case, because he may well have an appeal from that?
Yes.
Leaving aside that, is it clear that in the Superior Court action, the only relief sought is habeas relief?
No, Your Honor, because he brought the Massachusetts Parole Board in to talk about the wrongful revocation of his parole.
Why wasn't the relief that he was looking for something that the chief administrative judge grants? Don't we have a rule that permits removal of cases to a certain other court, to a particular other court for disposition? Why does all this have to come through the single justice?
It doesn't have to come to the single justice, Your Honor. As a matter of fact, he could have sought the ordinary appellate procedure, and that would have actually been proper.
Can I ask you another question?
Certainly.
With respect to the new filing that brought in the parole board,
Yes.
what action has been taken in the Superior Court on that filing?
It was a motion to dismiss, and the motion to dismiss was granted.
And was an appeal taken from that?
No.
Okay. With respect to the habeas, the piece that was still pending and the judge treated it as both, in that it's clear that the only relief sought was habeas relief, the first Superior Court.
Correct.
Okay.
So that's about it, isn't it?
It is, Your Honor. If there are no other questions, I'll rest on my brief and the
Thank-
motion to dismiss.
Thank you, Ms. Badway.
Thank you.